Hello, I'm Claudia St. I'm the president of Affinity HR Group, and we are here today to talk about the Families First Coronavirus Response Act and the new CARES Act that was just passed into law on Friday, March 27th. So I'm going to provide a fairly high-level overview of these laws and what you as a business need to know about them. And I'm going to answer a few of your questions. I'm taking this offline right now, so we don't have any attendees on this webinar right now, but it gives us the time to address the questions that we have been hearing a lot of. So at Affinity HR Group, we are the HR partner and resource for thousands and thousands of small to mid-sized companies and quite a few large companies nationwide. We partner with many associations. Many of you are probably a member of the associations that we partner with to try and provide resources to you, usually in times of prosperity, such as helping you with your employee handbooks and doing recruiting and headhunting and all of the things that you need to do to manage a fully functioning and profitable workplace. Today, we have turned into coronavirus response headquarters, all coronavirus all the time. So this is our attempt to provide as much information to you as we can. I'm going to provide this screen again at the end with our contact information. So if you have any questions, please don't hesitate to reach out to us with any questions. Again, I'm Claudia St. president of Affinity HR Group. My email is claudia@affinityhrgroup. Don't hesitate to email us with questions, and please link in with me on LinkedIn because we are posting a lot of information there, a lot of resources, and check our blog, our email website, or our company website is at the bottom there, affinityhrgroup.com. If you do affinityhrgroup.com/blog, keep an eye there because we are trying to provide as many resources as possible. Paige McAllister is also our Vice President of Compliance. She has most of the answers that we have questions for. That's who my resources, that's where I go when I'm stumped, and she's not available today, but she is always available normally and will always be happy to answer your questions as well. So the first thing I want to say as I start out with all of the webinars and presentations we've been doing recently is to know that this is a short temporary moment in time. No one has ever been through this before. So we are truly on a federal, state, and local level making this up as we go along. We're responding to issues and crises as they occur, and we're doing our best. And that's really all that we can do, is the best that we can. So you, as an employer, need to realize not only is this temporary, but this too shall pass. But the things that you do in the meantime, the benefits that you offer your employees, the programs that you put in place, the way that you respond to individual employee situations is not setting a precedent. We're doing this just to get through this crisis. It was pointed out to me recently that the Chinese government didn't notify the World Health Organization about this pandemic until New Year's Eve. We, as a globe, have not known about this for more than 12 weeks at this point, and we're all just trying to figure it out. So what you do is not precedent setting. So you just do what you need to do to address each and every one of your employee situations, and they may not be consistent. How you treat Joe may not be how you treat Steve because of the circumstances, the nature of their job, their ability to work remotely, their medical conditions, the conditions of their family. All of those things will be different. So treat them differently, and that's okay. As long as you're not treating people differently because of their protected class, such as their age, religion, their race, their gender, their health status, any of the other qualities, as long as you're treating everybody fairly, you can treat them differently depending on the circumstances. Not a normal thing that you hear HR people say. And finally, I just want you to remember that we're kind of in the MacGyver emergency toolkit stage here, which is we are making it up as we go along. So this is rubber bands and bubble gum, as I like to say. So you just do what you need to do. And remember, in these uncertain times, your employees are looking at you. They are watching you and how you react and how you handle this. So given that, do your best to tell them the truth, be honest with them. You don't need to blow sunshine at them when you don't know if that sunshine is true or not. Just you be you and as reassuring as possible, because brighter days are ahead. They have always been ahead, and they will be ahead this time as well. So the first thing I want to do is talk about the Families First Coronavirus Response Act, which we will use as the acronym FFCRA, because we all need to use acronyms. So there are two components to this act. One is the Emergency Paid Sick Leave Act. This extends sick leave under the federal government, and we'll talk about the second piece in a second. It applies to businesses with fewer than 500 employees. I don't know why. Don't ask me why it's only them, but it is. So this only applies to those with fewer than 500 employees. It requires that those companies provide a 10-day sick leave benefit to all of their full-time employees, which is basically 80 hours of average pay, 40 hours a week, so 2 weeks, or a prorated portion for those who work part-time. So basically, you're providing them with 10 days of paid sick leave at what their normal pay would be. The maximum benefit that you're required to provide to them is $511 per day, or a total over the total sick leave period of up to $5,110 a max for those being tested, treated, or diagnosed with COVID. So for those whose individual circumstances are affected dramatically by COVID, either they're diagnosed and sick with it, or they've been treated or tested for it, or they've been told by a doctor or government official to stay home due to an exposure. So they themselves have been exposed or potentially exposed to coronavirus. It also offers up to 2/3 of pay, or $200 a day max, $2,000 a day max over the 10-year period or the 10-day period for those whose children are home because their schools have closed or their daycare is closed because of coronavirus, or for those who have a family member who is actually ill with coronavirus and the individual has to be home to take care of them. So $200 a day max for those who are tending to children or sick family members, or up to $511 a day for those who have either been tested or who are being told to stay home. Now, we've gotten a lot of questions since this act came out. When this act came out, we really did not have remain in place or state emergency guidelines requiring closures of businesses and employees to and family members to remain at home and in place. So we've had a lot of questions. Does this mean that you're being told by a doctor or government official to stay home? Is that what it is? Is a state closure or a county closure the equivalent of being told by a government official to stay home? Well, we didn't know for a long time, but as of just yesterday, we received guidance from the Department of Labor that no, a quarantine is different. It means that you as an individual have been exposed, and under no circumstances are you to leave your home because you are potentially infectious. These other quarantines are not covered under this act. If you are sent home and you have no work, then you are no longer covered under this. You would collect unemployment and would be covered under the provisions of the CARES Act, which we will talk about in a minute. In addition, emergency paid sick leave is fully reimbursed by the government up to either the $55,111 over the 10-day period for full-time individuals or part-time individuals, or the $2,000, which is the $200 for those who are home taking care of children whose schools have closed or taking care of a sick one. It includes also any related health insurance expenses that you have over that period. To get the government to pay for this, you can withhold the Social Security payroll tax or the FICA tax that you would normally pay to the government. You can withhold that amount for an equivalent amount that you have spent complying with this act. If the amount that you're withholding doesn't tabulate, if you don't have enough FICA tax to cover that amount, then you can apply for an advance or a credit. Employers with fewer than 50 employees can claim hardship waivers, but you can only claim a hardship waiver for those related to child care expenses. So you cannot apply for a hardship waiver on the sick leave, the 10 days of sick leave, only for the 2/3 of pay up to $200 a day for those who are taking care of children. You can also apply to have the funds advanced to you. You would do this through the Small Business Administration. How you do that is still being rolled out, but I would encourage you to check out the Small Business Administration and the IRS. If you Google either of those and COVID-19 or coronavirus, you will get sites that answer a lot of questions on how to get these funds either withheld on a tax basis or advanced to you through the Small Business Administration. In addition, the Secretary of Labor has the right to exempt any business with employees with fewer than 50 employees. On what basis, we still don't know. So again, we're still getting clarification because just as we are rubber banding and bubble gumming our way through all of this, so is the federal government. So we're still not clear on that. But we know that they have the right to exempt businesses with fewer than 50 employees if they are healthcare providers or emergency responders. Those other businesses, we are still waiting for more clarification on that. What you need to do under this act is post your notice of responsibilities. This poster already exists at the Department of Labor. It's on our website. So all you need to do is Google FFCRA notice of responsibilities and posting, and you will get it. This act goes into effect April 1st. So as of April 1st, actually as of right now, you need to be posting this poster notifying employees of their rights. Again, this act goes into effect April 1st. So anyone who's out sick now, before April 1st, this act will not apply. You do not need to provide emergency paid sick leave to anybody who's out sick now. It only goes into effect on April 1st. You need to offer this emergency sick leave effective April 1st, and you can't require employees to use other PTO first before the Emergency Paid Sick Leave Act kicks in. You need to pay first out on the emergency paid sick leave, and then after that is exhausted, then you can require or have or allow employees to use other PTO. You can adjust your PTO after the law goes into effect. Nothing precludes you from doing that. You can also apply for waivers or have advanced funds if you have fewer than 50 employees, which we just discussed. You can also start withholding those taxes each quarter or however frequently you pay your payroll taxes, or get reimbursed for providing emergency paid sick leave and related health insurance expenses. Again, some of these waivers and how to advance the funds is still a little vague, but again, I would check out the IRS and the Department of Labor and the Small Business Administration sites to see what guidance they can offer you. The second piece of the Families First Coronavirus Response Act is the Emergency Family and Medical Expansion Act. This is the equivalent of basically family medical leave that is paid. It applies for employers, again, with 500 or fewer employees, and it covers those who have worked at least 30 days and those who cannot work remotely, so they can't work from home, and they are unable to work because they have to pay for childcare for a child who is out of school or whose daycare is no longer available due to coronavirus. This is for children who are 17 or younger. The first 10 days of this sick leave is unpaid, but they can use their PTO, or if they qualify for emergency sick leave, they can use that emergency sick leave benefit. After which they have to be paid up to 2/3 of their pay, or a maximum of $200 a day, for 10 weeks, not to exceed a total of $10,000 plus any related health care expenses. So basically, this is a 12-week paid leave for those who are home taking care of children. The most they are eligible for is up to 2/3 of pay, up to $200 a day, or $10,000 over the total 12-week period. Again, it's fully reimbursed, just like the Emergency Sick Leave Act, through either withholding your FICA taxes and payments, or through getting an advance. And again, if you don't have sufficient FICA tax to cover that cost, you can apply for a credit on future income taxes. Employers with more than 25 employees have to restore those employees to the same or an equivalent position without the loss of benefits. If you have fewer than 25 employees, you don't have to restore the equivalent position if the position doesn't exist anymore because of your business changes or economic conditions that are the result of this emergency. So, for example, if this employee has exhausted their 12-week family leave to take care of a child and wants to come back, but you're still on an emergency shutdown or reduce work because of the pandemic, you don't need to provide or restore that employee. And if the employer makes a reasonable effort to restore the position and the employer's unable to do that, again, because they're not in an economic position to be able to do so, or they try to reach out to the employee, but the employee is no longer available. The Secretary of Labor can exempt employers with fewer than 50 due to hardship. And again, some employers who are small can claim hardship, financial hardship. To do that, as far as we can tell right now, you need to document the fact that providing these two leaves, the sick leave and the medical family leave, would significantly create a financial hardship to you that would damage or make you unable to perform your businesses. You need to document that. My advice to you is to get an accountant and an attorney to review it to make sure that your argument is sufficient, that doing so would provide a hardship because, again, 100% of your cost to provide these benefits is reimbursable by the federal government. So you really do have to work to make that claim. But if you are making your claim, that's really the due diligence that you need to do. Now, if you fail to provide these benefits, your employees may not sue you. They have no legal standing under this Department of Labor, this the Families First Coronavirus Response Act. But the Secretary of Labor can pursue you legally. I should also say right now, nobody at Affinity HR Groups are attorneys. We are not attorneys and we are not accountants. I cannot say that enough. We are HR professionals interpreting this law. So any conclusions that you draw as a result of this webinar, you should run by the appropriate financial and legal advisors that you would normally run these things by. Really good sites for you to check out. The first is the IRS or the Treasury Department. They both have the similar information relating to how you comply with the Families First Act under the coronavirus circumstance. So your obligations under these laws is pretty well documented from a financial standpoint with the IRS or the Treasury Department. The Department of Labor also has a really great fact sheet for employers, fact sheet for employees, and very robust questions and answers. That's really where you're going to get most of your questions answered, is through that site. So put that a bookmark on your website to make sure you're keeping an eye on that. And then, of course, if you're applying for some loans, the Small Business Administration is your source for information on what you are eligible for. Now, I'm going to scream through this. This could be an entirely separate webinar on its own. But as of yesterday, Friday, the March 27th, the Congress passed and the President signed into law the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. And this is a robust program of providing relief to employers who are affected by coronavirus and to individuals who are laid off or face hardship as a result of coronavirus. So what it covers, looks like I have all of my animation screwed up. So we're just going to look at it here. So for employers, there is a payroll protection loan. This is a loan that can be taken out that covers 2.5 times what your normal monthly payroll costs would be. So that payroll costs would include payroll, health insurance, benefits, rent or mortgage, your utilities. So your normal operating expenses for your business, what your normal expenses would be, you can get a loan for up to 2.5 times that monthly amount, up to a total of $10 million. And that's for businesses that are fewer than 500 employees. If you, within the 8 weeks of obtaining this loan, do not decrease your payroll or reduce your work, if you stay fully operational at the pre-loan levels when you take this out, you can have up to 100% of this loan forgiven by the government. If you are unable to do that, and you are unable to keep your workforce consistent, there are certain provisions if you then restore them later. And the loan itself, under all circumstances, is valid, guaranteed for 10 years at no more than 4% interest. So this is really a financial lifeline that is put out to employers, so check that out. The provision also includes a refundable employee retention credit, which is up to 50% of each employee's wage, no more than $10,000 per employee, regardless of the size of business. If it's a large business, if you have had a significant reduction in business, if it's a small business, simply just retaining employees during this time, you can get a credit of up to 50% of wages or $10,000 total per employee. The Act also expands disaster loan programs through the Small Business Administration. So you want to check out the Small Business Administration for guidance on all of these components. For individuals, there is an individual stimulus payment that is going to go out to all Americans who work, non-students, but all adults who in the United States who file taxes or who have filed taxes in the last few tax years. The maximum is up to $1,200 per individual or $2,400 to families for those who make between individuals $75,000 or less and families $150,000 or less. There's also a $500 per child tax credit that's available. And there's a sliding reduction in payment for those who make between $75,000 and $99,000, or families earning between $150,000 and $198,000 for couples. This is expected to be released shortly. Within the next few weeks, we should be getting either payments, checks in the mail, or direct deposits if that's how you have normally received your tax refunds in the past. It also expands state unemployment programs to those who are currently unemployed. What it does is every state has its own state maximum weekly benefit, and it usually ranges between $400 to $600. In some locations, it's a little higher or lower, but that is a state weekly maximum that's available. It takes that state weekly maximum that an individual would be eligible for and adds $600 per person receiving unemployment regardless of their income. So basically, they're handing out an additional $600 a week to everybody who is collecting unemployment at the state level. And again, these are state level programs, but these are benefits available to everybody across the country. And most states have a maximum payment period of up to, usually it's about 24 weeks. And it expands those 24 weeks by an additional 13 weeks. So 37 weeks if my math serves me correctly. It also has a pandemic unemployment assistance program. This is for folks who normally can't collect unemployment. So gig workers, freelancers, contractors, independent business owners, those who don't normally qualify for for unemployment can get up to $600 a week unemployment plus half of the normal state weekly unemployment maximum benefit. So a big benefit to those gig workers and those who don't normally qualify for unemployment. So these two acts put together are really the sum total of what businesses need to figure out between offering leave to employees while you can stay open, getting some refunded payroll loans and available credits to those who can stay open. But if you can't stay open and you have to close your business, you no longer are liable. If you have to shut down, you are no longer liable to provide those family first benefits of sick leave and paid leave. The employee would then roll over onto unemployment and receive these benefits. So those are really those two major bills. I'm going to answer a few questions at the end. Of course, if you have questions, the first thing I would recommend you do is check out the Department of Labor, their question and answer section for businesses. I would also check out the IRS and the Small Business Administration for the provisions of the CARES Act, since most of that is done through a tax or loan basis. But those are the two resources packaged together that the federal government is offering as aid to businesses affected by coronavirus. Now, for those businesses that are closing down, we have received a lot of questions. A lot of them are being closed down. Some are being closed down because they simply don't have business anymore. They would operate if the business was still there, but they don't have the business, and so they're closing down. We also have a lot of those who are closed down, not because the business is not there, but because either the state or the locale where the business exists has put in place a mandatory stay-at-home notification requiring that only those deemed as essential businesses may stay open. I've had a lot of questions about what is an essential business. The thing I would recommend you do is to Google the CISA for identifying critical infrastructures and who is an essential business. They are updating this regularly. So check to see whether you can make the claim or the argument that you are an essential business. And also each state or locale issuing that stay-at-home order is providing guidance on what they deem is an essential business. So check these two places to make sure you can justify a closure. I would recommend that you seek legal counsel for doing that. I know many of the associations that our members are part of are trying to provide as much resource and cover really for the businesses that are covered under the that would be considered essential businesses under these mandated closures. But I don't think any of them are all able to say without a doubt you are covered. So that argument, that proof of argument, is always going to remain with the business. So for example, while the label printers may assume, or the building service contractors may assume that they are essential businesses, we would all assume they are essential businesses because they either produce something that's essential within the infrastructure that's considered essential, such as a label for a pharmaceutical or a medical device, or a janitorial service, cleaning. If you are not providing a label that is part of the infrastructure, so for example, you're only providing labels for toy manufacturers, or as a building contractor, you are only cleaning, small residences that no longer would be covered as an essential business, you may not be covered. You need to seek that guidance yourself, but I would look to your associations at least to see what they recommend. I also have just yesterday is the first time I have heard companies come to me because their employees have been stopped by state police or by police in their jurisdiction, demanding any notification or order allowing them to be out driving around in order to go to work. So increasingly, we are seeing employees needing documentary evidence or orders that they are an essential business and should be free to move about and go to work. So increasingly, we're going to have to be providing that. There's no guidance on how to provide that. So again, I would check with your state orders if they are providing them in order to allow you to be out and about. If you have nothing else, I would think a letter from your employer with some legal validation showing that you did your best to prove that you are an essential business would be important. For those that are in operation, we've had a ton of questions about what happens when Sue has a fever. Can I make her go home? What happens if Lou's in the office? He's elderly and suffers from COPD. Can I make him go home? Can I test employees? Can I take their temperature? Can I require that they take a COVID test? Many of these answers are going to be on the CDC guidance for businesses. So the Centers for Disease Control has a really robust and very effective question and answer. So I would go and check that out first. That is my go-to. These are the resources. The resources that we're providing here are the resources that my entire team uses in order to answer the questions like these. But let me take a moment and say a few things that have come up with questions and answers. First of all, if you have an individual who is at high risk, so for example, Lou, who's elderly and has COPD, would clearly fall into the high risk category. You cannot make them go home. You cannot make them do anything other than their job. You can, however, under the Americans with Disabilities Act, offer an accommodation for them to go home. So offer for them to go home. If they cannot work at home, offer for them to go home and use their PTO. Maybe offer them some expanded paid time off since they should be home and can't work for home. Again, those are the kinds of bubblegum and rubber band benefits that you can offer to individuals on a one-off basis if their needs require it. And then Lou can make the choice whether he wants to go or not. So under the Americans with Disabilities Act, we cannot discriminate against somebody or in favor of somebody based on their health condition. You can only offer a reasonable accommodation, and if the employee takes it, great, and if they don't, that is their choice. You cannot make them. The EEOC has determined that you can take the temperatures of your employees at the beginning of shift work. If you do so, you should do so for all employees and regularly. So don't just test those folks who are of racial, religious, ethnic, sex, gender, age, disability status. You test everybody. My only concern and hesitation about doing these testings is that you do realize that folks who can take a fever reducer and reduce the fever will not be captured if you do fever testing, and many people who are found to be infected with coronavirus don't develop a fever. So it's a very ineffectual way of keeping coronavirus out of your office. The best way to keep coronavirus out of your office is to provide guidance to employees. If they're not feeling well, they should stay home. If they are suspected or have been found to have an exposure to coronavirus, they would qualify for the emergency sick leave. If you have employees coming to work, socially distance them. If you can have employees work from home, some employees may be able to work from home, such as your accounting or your HR or your customer service reps. If they can work from home, have them work from home. Literally everybody you can have that works from home should work from home. That's the other thing I want to say actually about the Emergency Act that I didn't talk about with the essential businesses. Just because you're deemed an essential business and can stay open doesn't mean that you should stay open. If you can work from home, if your employees can work from home, let them. Those that do have to come to the office, my recommendation is that you socially distance as wide as possible. Bring employees into the equation of how they think that they should restructure their offices. If you can have somebody work out of a utility closet in order to socially distance, do it. Again, it's not forever. It's just rubber bands and bubble gum. Again, check out the CDC site. So just to go through some common questions that we've been asked, excuse me. Does a state or county order that requires that people stay home, if those employees can't work from home, does that mean that they can be covered for under the sick leave, the emergency sick leave, or the family leave? No, it does not qualify. If your business closes down, If the restaurant closes down, if your business closes down because of an order, a state or local order, you would not qualify for the family leave or the emergency sick leave. You may qualify under the CARES Act, and employees would qualify for expanded unemployment. What if an employee self-quarantines and refuses to work out of fear? We have a lot of this. A lot of people are very fearful. Either they are at risk or they're not at risk and they live with somebody who is at risk, or they're just fearful. If they are, you can require that they use up their PTO. But after that, if they are no longer able to have any pay coming from you, they would then fall into the category of unemployed and could seek unemployment insurance. I am not clear yet, just because the act came out yesterday, if an employee quits, because normally under state unemployment insurance, if an employee quits their job, they're not eligible for unemployment insurance. I suspect this is the same. I suspect if an employee just says, not doing it, not working, they would not be eligible for this unemployment benefit. But you need to check with your state. Again, each state has its own rules. And while the federal government has made a few of those rules that they normally require, they've made that lax. States have the choice whether to make some of those requirements lax or not. So you need to check with your state. But that would be the only thing that would be available to somebody who just isn't working. What if an employee's family member is at risk? Again, if an employee's family member is at risk, that doesn't mean that they're sick, and it doesn't mean that that your employee is at risk or sick. This would fall into the previous category. If they are at risk and they don't want to bring illness into their house, that is totally reasonable, but that does not mean that they would qualify for emergency sick leave. And unless they're tending to childcare, they wouldn't qualify for the emergency paid leave. If it's a reasonable concern, you may want to extend some sort of benefits, or you may not dispute their unemployment benefits if the unemployment board would preclude them from getting coverage. So, for example, if you have an employee who has a child at home with a severe autoimmune disability for whom any exposure could be fatal, you may want to treat that person differently than, a person whose husband, just is at risk for whatever reason, and they don't want to bring that home. Look at it on a case-by-case basis. Do not discriminate based on anybody's race, gender, religion, age, disability, gender. But if you do need to make those changes on a case-by-case basis. If my employee claims that they've been exposed, but they have no proof, how do we know that? They should be able to provide some proof. Now, somebody who is sick, you shouldn't require that they have a documentation to the extent that you don't want them having to go into a medical facility, because those medical facilities are taxed. But if they can at least get some sort of information to validate proof that they're sick, then do so. Now, the other thing is, if it happens right now before April 1st, they're not going to be covered anyway, because that sick leave benefit, it doesn't exist until April 1st. But my advice, and I have a lot of clients who are like, look, I've got knuckleheads. They're going to take advantage of any system and any possibility that exists out there. While that makes me very sad and hurts my soul in the first place, recognizing that is a possibility, I would err on the side of not having those employees show up to work, because you do not want, in the case of this global pandemic, for people to be in this situation. Can those on emergency family leave take it intermittently? Yes, you can. If you have an employee who shares childcare responsibility with her spouse, and her spouse can take off 2 days a week and she can take off 3 days a week, can they take it intermittently, each of those employees? Yes, they can. So that is a new guidance that just has been put out there. What is available for laid off or furloughed employees? If you're laying off or furloughing employees, really the only thing other than paid time off is unemployment. Now, one thing that is available, so for example, a lot of companies are looking at reductions in force because of low client work or low, that business is off. They're still able to stay open, but business is off. For those folks that you furlough, you may want to consider paying the employer portion of that individual's COBRA coverage. So that way they won't lose health insurance, because when you lay off an employee, when they go on unemployment, they typically lose their employer-sponsored health care coverage and go on COBRA, which requires that they pay that premium. Of course, this is a really tough time for anyone to be paying the health insurance premium. So for those employees that you lay off, you may want to consider offering some sort of health insurance extension. But otherwise, there really isn't much out there for them. Can I require my employees to get tested? Well, I don't believe you can require them to get tested without there being a medical reason to do so in special circumstances. For example, if you are simply a floor covering distributor, testing your employees, having your employees get tested probably wouldn't be allowed. Usually a doctor has to be the one to allow an employee to get tested. And given the shortage of testing out there, they're probably keeping those tests available only for those who had risked an exposure. So unless you operate a nursing home or a facility where any kind of exposure would be detrimental to the health of everybody there at that level, typically we're not seeing employers on their own simply being able to have their employees tested. It's a medical procedure. Most medical procedures are precluded under the EEOC. You cannot require an employee to undergo a medical procedure. However, you can, and this is the last bullet, the EEOC has said that you can take the temperature of employees and you can require that they stay home if they report symptoms that are consistent with coronavirus. Again, check out the EEOC, which is the Equal Employment Opportunity Commission website, or that CDC resource guide for employers. Check that out as well. Again, you want to do this as consistently as possible and as fairly as possible. And more than anything, if your employees can work from home, let them work from home. And if your employees cannot work from home, do what you can to soften the blow for them. Check out these resources and see what's available to them. And for those who do come into the office, practice social distancing. Close down your kitchens, close down your coffee machines, shut down your water fountains, provide bottled water if you can, wipe down frequently those commonly used surfaces such as doorknobs, bathrooms. Make sure everybody is cleaning their own workstation, and everybody should stay no closer than 6 feet away from each other. So these are the things that you can do. Again, this is a very fast-acting situation. We are responding to calls and inquiries all around the clock, and we will get to yours if you have any, if we can. I do encourage you to check out our website and our blog at affinityhrgroup.com/blog. Check in with me, Claudia St. John, at LinkedIn. We're providing a lot of resources there. Or email either me at affinityhrgroup.com or Paige at affinityhrgroup.com, or just contact at affinityhrgroup.com. We are here to provide resources to you. Your associations are doing a lot to provide resources. Check out their sites. Check out their coronavirus sites. Most of them have something available to you. And if not, there are certainly sites available within the government, and we have resources available too. So that's about it for now. I hope that you all stay safe. I hope that you all are healthy. I hope that we can get through this together so that our ascent into good times is as rapid and robust as our descent into this current situation. And more than anything, we hope that you have a safe and productive work week. Best of luck to you all. Take care.